process that we attorneys, legal representatives will have to follow to file or to register a company. Our process is similar to this one, but entails a couple more steps that individuals or company representatives don't have to go through. So this is about you, and if you want to do your own registration, this is what you need to know to have a successful registration. Registration doesn't mean selection. It's just you're going to register and wait for them to do the lottery, and then you will be notified if you were selected, and then you can submit the H-1B. So the first step, you will have to create an account, and the Department of Immigration already announced that they will not make this software available until February 24th. So you can still go to the Department of Immigration website, and the link is there, myuscis.gov. Go there, you can see and create an account or register, sign up. If you have never created an account, creating an account is the same process as the normal process you use when you are creating any account in with any program. So you have to go in with your information, name or email, and then get a password. Once the account is created, or you are into creating the account, you have to select what type of account. In your case, if your attorney or legal representative is not creating the account, but you, employer, doing it directly, then you have to choose I am an H-1B registrant, meaning you are registering your own petitions. This doesn't mean the beneficiary. This is always employers. Remember, H-1B visas are employers based on employment, so it's not like an individual who's going to be sponsored can go in and register. That's not how it works. It always has to be the employer.
The prospective petitioners are the registrants.
Yes. So then you pick or select your account type, and again, since you are the registrant, that's the selection, is the third bullet. What information you have to provide? Well, we have always, from the beginning, said it's basic information. Company legal name, full legal name. So, for example, Cowles and Thompson PC, that's our full legal name. And in most things, we just go by Cowles and Thompson. So that might be our doing business as, but if you have a doing business as, you have to enter that information. Also, your federal employer identification number. That's basic information. They're going to verify it's a valid federal employer identification number. Primary U.S. address, and when you are logging in or when you're creating your account, they even give you options for a second address. So if you have a primary U.S. address, but you have like where you receive all the mail and everything, you can enter your second address there. And the information about the authorized signatories information, meaning the person who's going to be signing the forms and anything related to the H-1B filing. Full legal name, I mean, first name, last name, and it has a middle name, that as well. Title, it might be president or HR manager or whatever the title is, and the contact information, email and date, time, phone number. If it is a cell phone number, that's fine, but a phone number where if the USCIS needs to reach these individuals, you need to provide that number. That's all for the employers. Then you go on to the beneficiary.
So the beneficiary information that you'll need to provide is minimal, but it needs to be accurate. Again, we'll need full legal name, I want to know gender, date of birth, country of birth, country of citizenship, and very important, passport numbers. So we know multiple countries have been having issues with passports. To make sure that these beneficiaries are on top of getting their passports to get their passport number. Let's see, primary U.S. address and that where they will be landing.
Mm-hmm. Correct.
Okay. So now what is new and what is really sort of the new thing we've been grappling with is this USCIS. To come in through the registration process, it will be $10 per person per beneficiary. So the prospective employer petitioner is the registrant. Once you come in, you can register a max of 250 people per registration. That's important to know because if you're going to be filing for more, you'll have to go in and do a separate registration for the next, whether it's another 50 or 200, whatever the batch is.
Mm-hmm.
And then, of course, the payment, when you process the payment, it will either have to be a debit through a checking account or a credit card. So that's very minimal, but that is part of this new registration process. So when you go in there, once you have entered all this information, you have your information as the registrant and then the potential beneficiaries, you should be able to click on, and this is available through USCIS. This is just a sample of what you'll see. You'll see all of your beneficiaries listed right there with some of their information. And that's how you know that you have entered everyone that you're intending to enter. And well, here, let me go back to the last slide. If you see under the status, after they have run the lottery, you should, as the registrant, be able to log in and you'll be able to see the status change on there.
Yeah, but before we go into that one, go back to the, if you see there, once you have entered all the information about the individuals you want to sponsor, then you're going to be able to see the status of that, whether it's selected, submitted, denied, not selected, selected. If you see there's a denied, before this, when you look at the status at the end, it will give you an option to delete registrations. Remember, the registration period is going to be from March 1st to the 20th. So during those 20 days, you can still go into the system and make changes to a specific registration. So if you want to delete a specific name, or if you want to change the name because you spelled it incorrectly, you can still make those changes. But after March 20, then you can make changes, and then it's where you're going to see the status of the petitions are selected or denied. What is the denied for, Michelle?
So denied there, where it says in parentheses duplicated, that's a situation where this person has multiple registrations and you're not allowed to duplicate. That's just it. That's sort of been the law. That's been the law for a long time. Except this way, USCIS is trying to identify those duplicate filings more easily through this electronic registration. So basically, if you duplicate, they will all be invalidated. They'll be denied. You cannot proceed. So then what we provided right here is a link, and you'll see it's the overview to the H-1B electronic registration process. So a lot of these slides that we've pulled from to give you some information can be viewed independently on the USCIS website through their electronic reading room. You can get to it through their main website, uscis.gov, and look on the left side and you'll see where you can go into the reading room and you should be able to pull up their actual registration process slides that we're showing you now. Now, this is critical because this is a new process and everything's date driven. Angela, please give us the highlights of the most important critical dates with this new process.
Yes. So what you need to keep in mind, and if you want to print this slide and put it somewhere, you're going to have this date, and so that you know when your deadlines are. So we know from the Department of Immigration that February 24th, the first day, at 10 a.m. Look at the time. So if you go before 10 a.m. it is time, then you're not going to have access to the account. But they even gave us time. So
yeah, it's a little stressful. We're Central Standard Time, so we're having to translate these times to make sure we're accurate.
But we need to keep in mind those times. And I'm pretty sure that at least for the first 24 hours, the system is going to be pretty busy. Hopefully it's not going to collapse. So on the 24th at 10 a.m. Eastern time, employers are going to be able to start registering H-1B account.
Now, USCIS did emphasize that you're not required to register on March 1st. And obviously the speculation is they don't want the system to be overrun and collapse on March 1st. There's no requirement. You have the window of 20 days. Obviously, most people will want to do it on the front end as early as possible, but you do have that window.
Yes, but keep in mind that you can create your account on 24. That's 6 days before the March 1st. My advice, and is what we will be doing in our firm, we're going to be creating our accounts on the first day, because if anything goes wrong, we want to make sure we have time to communicate with the agency. They say that there's going to be a help desk ready and available to be helping people who have difficulties opening accounts, creating accounts. Remember that when you create the account, you have to create a login information, have a password, and if anything goes wrong and you don't have access to your account, then you can contact the help desk. More than likely, it's going to be via email. And they say yesterday on the phone call that we had with them about the process, they say that the help is going to be prompt and fast. So my definition of prompt and fast, since we don't have a lot of time, would be within the next 5 minutes after you contact them, and that's not realistic.
We don't know if that's going to be the government's same definition of prompt.
Exactly. But the way I see it is, if I'm given the opportunity to create my own account beginning February 24th, I think I can start doing it on that day. Then that's just to create your account, making sure everything is ready for you to start registering those H-1B individuals that you want to apply under the cap. So first date is March 1st at noon Eastern time. Employers can start registering the H-1B beneficiaries or accounts. Now, as Michelle mentioned, the registration period is open through March 20th at noon Eastern time.
That's the cutoff.
That's the cutoff. That's your deadline. If you do not register that individual or that account by March 20 at 12:01, then you're out of luck. You have to wait until next year. But the time frame is March 1st at noon to March 20th at noon to register 220 or 1,000 beneficiaries, if that's what you are going for. Remember, it's $10 per registrant. Then after that, they closed registration, and government has said that by March 31st,
so they said
they will complete the lottery. The lottery system, as we explained at the beginning, and I was going to go over again, is working to some reasons last year, how they select the petitions.
Right, and that's where once on the 31st, you should be able, as the employer registration that registered, go into the account and see which one of your beneficiaries were selected. If they were not selected, if any of them, as you recall, were shown as duplicated or denied, that's what you'll know. And you'll see the list come up, and hopefully you'll have mostly selected. But
yes, so then if you see that you were selected, and they also are supposed to send notification.
Yes.
But if you're selected, then you have 90 days from April 1st to file the H-1B visa.
And now this is a process that looks identical to what we've seen in previous. You have your forms, filing fees, and all supporting documentation required for the H-1B needs to be submitted within this 90-day window. So you know you're selected, and that's when you can submit all the supporting evidence and forms for your case.
Yes, the regulations, the process in terms of once you submit the petition and the requirement to meet the petition, nothing has changed. We've done webinars before on that, and today we're only going to touch on a couple of subjects, but we're not going to talk about how you prepare your H-1B visa. So make sure that you prepare the H-1B visa completely, that you document everything that you are trying to prove. Company existence, operations, it's a U.S. company, the job, the requirements, the individual meet the job requirement. And one interesting, and we'll talk about that later, is about the job requirements. So you want to be careful there how you tackle that. The 90-day deadline to submit the petition, which means you can submit it on the 29th, so it lands at the Department of Immigration on June 30th, and you're still on time.
Oh, it's so scary.
Yeah. So there was a question we had a couple weeks ago, and then somebody was asking about the OPT, the gap OPT, what happens with those individuals who are subject to OPT and their EADs expire sometime in the summer, maybe May. Do they have to wait until June 30th? So what will happen there, Michelle?
So the confusion is whether or not this is going to affect how you get this cap gap protection. And what
is a cap gap?
The cap gap is going to be that work authorization that bridges you from the end of your EAD expiration until October 1st. So if you were selected and your H-1B petition is pending with immigration, you should be work authorized for that period of time that your EAD is expired. But because you were selected, you're seeking to bridge that gap until October 1st when your H-1B, upon approval, would take effect. So the question was, with the new registration date and whether you know you've been selected, and between the window of April 1st and June 30th, what happens? What do we get cap gap protection? How do we go to the ISO to get the I-20 issue, to process everything, to process and show everything? And CIS answered that question very clearly. And they said it's still the same rule.
Yes, but the process, again, remember, the only thing that has changed is how the lottery runs. It's based on a registration rather than a 200,000 petitions file. So once the petitions are selected, people have 90 days to submit the petitions. And for cap gap, as it has always been, for people to be able to extend the EAD beyond the expiration day, as Michelle explained, they have to show a receipt from the Department of Immigration that the H-1B petition was actually filed for change of status. So with that, that receipt is not going to be issued until the H-1B is actually filed.
Right, until they cash the checks.
Yeah, so here is the thing. You can show it. You can have in the system and show that the petition or the individual, the company was selected to submit a petition for that individual. But if it is never submitted, you might as well not have been selected. So it is about the receipt. It continues to be about the receipt. So for those, our advice for those who are subject to OPTs and they rely on the cap gap rule, our advice is to file if you are selected. File that H-1B petition as soon as you can after April 1st. So the earliest, the better, so you can get that receipt and have your EAD extended as allowed.
Excellent. So because this is H-1B, we're just going to go very quickly over some of the hot button issues that come up in the H-1B analysis. We're not going to spend a lot of time on it. We do have previous webinars where we've gone at length describing and going over H-1B requirements.
But before we go into this, let us go over a couple of questions we received what we were talking. And thank you everybody for submitting these questions about the registration. So the first question is, I am graduating with a bachelor's degree this coming May. Can I have an employer submit a registration for me in March based on that degree?
Well, the answer is yes. Again, the law has not changed. And so concepts that we've applied in previous years still are going to happen here. So as long as the beneficiary completes all of the degree requirements before the petition is filed, this is absolutely permissible.
Yes, so keep this in mind. So registration, employer can submit the registration between March 1st and March 20, no problem. If you are graduating in May, so make sure to start working on preparing the petition, but do not file it until your graduation date. So if you graduate on May 15 and you get that degree, then on May 20, you can be sending that petition to the Department of Immigration.
Yes.
Remember, there's 90 days. It will bring us up to June 30th.
And it preserves that you were you met the requirements at the time of filing.
Exactly. Can I submit an H-1B registration on my own? Do I need an employer to do this?
Well, I think we answered that earlier, but just to clarify, no, a beneficiary cannot submit an H-1B registration. This has to be done by the prospective employer or the employer's legal representative or attorney. So this is not going to circumvent or change H-1B filing. H-1Bs are filed by employers and not by the employee beneficiaries.
One more, and then we'll move on with the rest, with the other, and we might have a few more questions at the end. So can more than one company submit H-1B registrations for me?
Well, it is possible. Of course, you always want to look at whether these entities are related, because that's where you get in trouble. But so long as the entities are not related or affiliated, then that is absolutely permissible.
Exactly. So remember, what you can or the employer can do, because then they'll deny everything, is to submit several registrations for you. Same employer and you, or same individual, same registration, they'll deny all. You wouldn't even have a chance to get into the lottery.
Exactly.
So now we're going to move on with this basic information. And again, we're not going to go over the entire H-1B presentation because it will take more than an hour, but we're going to touch base on a couple issues or subjects that we have seen are the major causes of denial in the last couple of years. So
first one is, what is a specialty occupation? USCIS has been hitting specialty occupation issues a lot over the last 2 years, increasingly in more recent time. They want to know that the H-1B position is that of a specialty occupation. The definition is it requires highly skilled, specialized knowledge and a bachelor's or higher degree or equivalent in the specific specialty as a minimum for entry into the occupation. So you can see that it's very specific, but it also there's a lot of room to argue.
So let me give you let us give you a couple of examples. We're talking always go from it requires at least a bachelor's degree or equivalent. And what is equivalent? And we've done this in previous presentations, is to have the equivalent of at least 3 years of experience for every year of college. So in the United States, a bachelor's degree normally is 4 years. So you should have at least 12 years of experience, and then you have to do the equivalency, or that your foreign degree is equivalent to a 4-year degree in the United States. And that qualifies for highly specialized knowledge and a bachelor's or higher. Highly specialized knowledge is defined by how much do you have to study to obtain or gain the knowledge for specific occupation. So there are in the law certain occupations that are already determined they are a specialty occupation. And for example, physicians, engineers, there's a bunch of them there, accountants.
For the accountants, we've gotten a little pushback because they've been hitting the multiple levels that within accounting, right? So for example, we had an RP that came back and said, well, this looks more like a bookkeeper, and it was not a bookkeeper.
But it's not because accountant, they are questioning whether or not the accountant is a specialty occupation. What you need to keep attention is how you describe the job, what the responsibilities are, because it's not just the title. You can give any title you want to the job, but they're going to look at what the job is about. And if the description is very basic, they're going to question whether or not it's a specialty occupation.
Exactly.
So make sure that is understandable.
Yeah, we have to explain that, no, this is really an accountant position that requires accounting, and the person was doing more than just bookkeeping. So we had to distinguish that this was a specialty occupation in this particular case, just as an example.
Correct. So when you are describing the occupation or the job, make sure that you put in key information, but understandable. Don't get lost in being too technical, because remember, the people reviewing these applications, they know what they're doing, but they may not be experts in every single field that these H-1Bs might be filed in. So don't expect them to understand things that you don't even know how to explain in simple terms. So specialty occupation is a big, big issue. Pay attention to job description requirements and how you classify the occupation.
Now, the next big one that we've seen a big jump in is regarding third-party locations, where you have situations where the employer has the employees working off-site. Angela, what can you tell us about that?
So this is tricky because, for example, if you have an employee who might be working at a location different from the beneficiary place of business, then that may not be an off-site because it might just be the work location, and it's a third-party location or work site because it doesn't belong to the employer. The perfect example we always give, and we do work a lot with physicians in healthcare centers. So frequently we have private practitioners that have an office, but many times these physicians might spend most of their time in a hospital. So the work location might be the hospital, not the private office. And so that's a third-party location. When we're talking addressing third-party locations, what we keep in mind, or what you need to keep in mind, is how to prove the employer-employee relationship. This is the employer or the company sponsoring the H-1B and the beneficiary. Because what the Department of Immigration wants to see clearly is that the employer has the right to control.
Yes, right to control is the big issue because they want to make sure that it's not necessarily been a situation where you're lending the employee.
Correct. So usually, what do we recommend people to include in those petitions, Michelle?
So oftentimes statements of work are big, and we will include the original contract to establish the work that needs to be done. And then we will include anywhere from employee manuals, badges and credentials that they have to present, meetings, regular meetings that they have. Obviously, we should pay stubs. We show that everything that the employee is doing is under the control, not of the contracting or the end customer, but rather from the employer. So if they're getting equipment, laptops, if they're getting any sort of equipment to go out there, that is all coming from the employer, and they have the control over that individual.
Yes. Also, we recommend to include any agreement that there might be between that third-party location or third-party work site with the sponsor or the employer, or a memorandum of understanding or a letter from the third-party work site manager or whoever is in charge of the work site explaining the relationship between them and the employer and why that individual is working at their location. And basically the letters just say, we have an understanding or we have an agreement with company so-and-so that their workers or their engineers or their physicians or these specific people will provide certain type of services at our location, including whatever. And that the employer or the sponsor is the only one responsible for that individual, including performance reviews, pay, salary, taxes, and other benefits. So that the Department of Immigration see clearly that no matter where that employee might be located, the employer is still responsible for that employee's employment.
Exactly. And then this one's been hit particularly in the last year or two, prevailing wage. So we talk about prevailing wage anytime we discuss H-1B with any potential employer, because this is just the reality of it. Employers must pay no less than the required wage rate. What is the prevailing wage? It's defined as the average wage paid to similarly employed workers in requested occupation in the area of intended employment. So the prevailing wage for a position in rural Texas may not be the same as that one in Cincinnati, or it may be different from those in LA. So we have to look at what the prevailing wage rate is for that occupation and the area. That's why the intended employment area is critical. So the employer must pay no less than that rate, and the required rate is the higher of the actual wage paid or the prevailing wage. So if you're actually paying higher than the prevailing wage, you don't get to drop them down to the prevailing wage. You have to bump them up to the actual wage for the other folks that are in the similar situated position. So,
which normally is not the case, because we frequently hear the employers and the companies we work with that the Department of Labor sets this prevailing wage minimum requirement sometimes a little high, and we have employers that come back and they say, not even my permanent employees get paid this much at this level, level 1 or beginning level. So
that's why you're laughing, because the prevailing wage, it's something that's set by the Department of Labor. It's not necessarily accurate. Our employers tell us all the time that these wages are skewed and they're not reflective of what is happening in the job market. And we have to tell them, I understand, but sorry, this is the law.
Exactly. And in certain situations, in certain occupations, the wages tend to be a little higher than in practice. So when an employer has a situation where the prevailing wage is determined by the Department of Labor is higher than what they normally pay other employees, well, the only choice is either bring that salary up to what the prevailing wage determined by the Department of Labor, or try to provide its own prevailing wage survey.
Okay, so here are the sources where they considered the prevailing wage. So if there's a collective bargaining agreement that's in existence, we file with that. We'll submit that with the LCA, and this is what we're basically saying. This is what's going to happen. This is what's been agreed to among the parties.
And they go abide by it, because if it is a collective bargaining agreement, they respect whatever wages, even if they are lower than what the Department of Labor could have determined. So that is a safe harbor.
Right. And then National Prevailing Wage and Center, that's where we get ours.
Determination.
Yes, we do the determination. Occupational employment statistics, the OES wages, that's pretty standard. Now, the one that's tricky and we get a lot of pushback from are the employer provided published wage surveys or employer conducted surveys. We've seen a lot of pushback in terms of whether or not the requirements were really met. These surveys, in order to comply, must meet. Oh, there you go. It must meet. Here we go. The data cannot be more than 24 months from the date of publication, which can be complicated because a lot of the sources that we've seen will publish every 2 to 3 years. There's some that come out every 5 years. They don't publish them annually, at least for most of the ones that we've run into. And the data should only cover the area of the intended employment. So sometimes you'll go through these service providers that will provide, national or the regional wages, and the region is just too big because it encompasses more than just the intended employment area that you're looking at. It's just too wide of an area. And this is where it gets fun. The survey must reflect an arithmetic mean, not a median. Well, I have to go back and look at those words and remember which one's a mean and a median and go through the report. It's a lot of work.
It is kind of hard, but luckily we work with a few companies that do provide private prevailing wage surveys. And one of the things that we always ask for them, even before they give us the determination, is to give us a summary of their prevailing wage requirements or parameters. And we want to see that they hit each one of these, specifically the arithmetic mean rather than median.
Oh, and then I don't like this one, that it be based on sound statistical methods. So we've had mathematicians provide letters to regarding the veracity of the statistical methods used in the surveys. And again, the 24 months, that's just, we can't get past that.
Yeah, but here is the thing. It is complicated if you're going to try to do it on your own. There are companies that provide the services, and they're very competent.
And they've changed it to where they can meet these, but you have to have absolute good source.
They need to meet these requirements. So when we are trying a new company, we already have a few that we know they meet these requirements. We have used them before, and their surveys have been accepted by the Department of Immigration and the Department of Labor when we do DLC. But when we're trying a new company, the first thing we do is we send them these criteria, and we want them to let us. They do meet these criteria to the last of the requirements, because the Department of Labor will not accept a private survey that doesn't meet each one of these requirements.
And then you're going to be subject to the OES wage.
Exactly. And the EOS wage is the one that we always go by normally. The best bet is to request a prevailing wage determination from the agency, but they take 3 to 4 months
Yes.
to make a determination. By then, you probably are out of time to file an H-1B visa.
So OES wages are always really the good benchmark. We start there with the conversation with our employers, and then if we have wage surveys, we definitely look at them. We'll look at other avenues, but OES is kind of the good starting point.
Correct. What we've done in the past with big companies that we work with, and we know the prevailing wage might be an issue once the wage is changed. Because remember, the OES update the prevailing wage levels every year by July 1st, the first week of July. So they do that. So what we've done in the past is we have been able to obtain the private surveys that gives us a favorable wage and submit a prevailing wage determination request from the Department of Labor with the private survey, telling them, here, this is what the wage should be. And we have been able to get, and remember, that prevailing wage determination is good for 2 years.
Yes.
So what we do is to use that determination for future H-1B, at least for 2 years, we know we're set with the wage, and we're not going to have surprises that if in a year we're going to find the same, an H-1B for the same job, we're going to find that the wage may be twice as much.
Exactly. Okay, and then the most pressing question when we're talking about H-1B. What's going to happen with the premium process with this new H-1B registration process and the way they have the repackaged H-1B?
I don't know. This is as good as mine. We don't know.
We don't, and that's really hard because the premium processing brings a lot of peace and continuity and also a conclusion to something very quickly. But in the past 2 years, particularly, we've seen that they've suspended premium processing for H-1B
capped.
For H-1B cap cases.
In other cases, but mainly for H-1B cap cases.
Yeah, they've gone as far as holding on until June, and then they would honor in June. We don't know what's going to happen this year.
We had, was last year where they suspended the premium processing for H-1B caps for so long.
Yep.
That remember we were in December.
Yes.
And we were still waiting for H-1B cap petitions to be decided. We couldn't premium process. People had to go out of the country because they were not under any authorization to stay or continue to work. I mean, it was a little messy.
And just for the record, we had an H-1B cap case from last year that was just approved last week. Yes, last week. So, and now this individual had, they could have at some point in time, they recovered. But again, I mean, I cannot imagine doing an H-1B cap case and not seeing it end until, I mean, almost before the next cap season.
And unfortunately, the individual that was waiting for this H-1B had EAD.
Yes.
So he could wait and continue to work. But the premium process for most people is about, like Michelle said, it's not only peace of mind, but also to know, and employers, if I'm expecting someone to start on October 1st, I want to know that we can start on October 1st. And if not, I want to know when, but not sometime in the future, because that's not how companies and business work.
No, that is not how business works, but the government has
the priority. Yes. Okay. So this is kind of, I know probably this presentation was a little fast and not a lot of information about H-1B. Our main purpose was to give you information about the registration process. Keep in mind the date. You know, we move the slide.
if you're ready.
Keep in mind the deadlines.
Yes.
February 24th, March 21, and March
Yes.
1st to the 20th, then April 1st to June 30th. One thing we're doing with our client, that we're working with the registration, we are not only just making sure we can register the individual or the petition, but also what we do to make sure that if the petition is selected, we're ready to just prepare the forms and send the petition. So we do make sure that the company and the employee meet the bare minimum H-1B requirements, so that when we file those registrations, they're not going to be frivolous registrations. And we know for a fact that those individuals who are filing registrations for or companies, they are going to be ready to file the H-1B if they are selected. It's only $10, and the attorney fees to do the registration, but not the full for the preparation of the H-1B.
Yep.
If you have a foreign degree, you also want to make sure that you have the degree evaluated.
Exactly. You want to make sure that you can argue the equivalency of your degree to that at minimum of a bachelor's degree in a specialty occupation. Again, the same rules apply. It's the same law. They're just revamping how they want to process it. So we keep reminding employers, you're having to do these additional steps, but the law and what they're looking for and the requirements are all still the same. So everything that you've heard before and you know before to be related to H-1B in terms of foreign equivalency, specialty occupation, prevailing wage, all of that still remains the same.
So if you have any questions, we have a question that came in. Let me read it for you. But if you have any other questions, please feel free to type it in your question box, and we'll be happy to answer. I found a U.S. company that is willing to sponsor me for an H-1B position, but I have to hire an attorney to file the case and cover all the costs. Is that okay?
No, it's never been okay. And there's been a lot of litigation against employers who've engaged in this practice. So please, please, please beware. The fact is, by law, there's fees that are associated with the H-1B process that have to be, by law, paid by the petitioning employer. Those fees, there's no way around it. For example, the fraud protection fee, the ACWIA fee, ACWIA fee, those must be paid. So this doesn't change the requirements. This doesn't change who pays for what. You know, again, it's a big no-no. We don't do that.
Yes. So employers, although they're only required to pay certain fees, not all of them, in case of an investigation, the first thing USCIS or DOL is going to look at is who paid for the fees, and then they'll start deducting these fees from the salary. The salary falls below that prevailing wage that we just discussed, they may be subject to sanctions. So we rather employers to stay away from them for peace of mind, right? And then rather than doing that, just take a look at salary, pay whatever salary is required, and just claim the H-1B expenses as a business expense.
Exactly.
Yes. I think that's, any other questions?
No.
Okay.
That's it.
I don't see any other questions. I think this is it. So thank you so much for being with us this afternoon. We really appreciate your presence, and please know that to keep you up to date, we are doing a seminar in April to give you an update on.
We're going to be updating you on current practices. We have the public charge rule that's going into effect starting February 24th. We're going to know what's been happening with the H-1B. We can report back on what's happening, what we've seen, and we will be providing other updates related to USCIS processing and immigration for you. So please follow us on social media. Please be sure to subscribe to our newsletter so you can get the the information regarding upcoming webinars, and we would love to stay in contact.
And for those watching us, watching the video, please feel free to contact us if you have any questions when we're going through the video or the presentation, and we'll be happy to help Thank you again. We appreciate your time. And until the next time.
Until the next time.